The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated, and when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Trust of Marsha, Milot. Case number 25 AP 061. Representing the appellant, Jennifer Milot, is Andre D. Buffard. Representing the appellees, Valerie Wiederhorn and Curtis Henniger, is Matthew A. Zadowski.
Thanks very much, and good morning, counsel. We'll hear from counsel for the appellant first, of course. Please come on up. And for the record, introduce yourself and your client, please.
I'm Andre Buffard, and I represent Jennifer Milot.
Thank you.
May it please the court. The core question in this appeal is whether the remainder beneficiaries of the Marsha Milot Trust, which is an inter vivos trust, can hold the trustees accountable to their fiduciary duties where the trust is functionally irrevocable because Marsha Milot is incapacitated. And
so the trust started as a revocable trust, and now because of her incapacitation, it becomes irrevocable. She can't modify it. She can't change it because she doesn't have the capacity.
the Vermont Trust Code, Your Honor, says that in order for a settlor of a revocable trust to be able to amend or modify the trust or revoke it, that person has to have testamentary capacity. And our contention in this case is that she does not have testamentary capacity. And furthermore, we contend that there is no other party that holds her power as her agent or representative who is able to exercise that
Have there
power.
been findings to about the facts that you're talking about here, that she lacks testamentary capacity and that there's no agent who is empowered to exercise her powers? Have there been
were no
findings of fact?
Yeah, thank you, Your Honor. Chief Justice Reiber, there were no findings because the probate division summarily dismissed the case without even applying the well-recognized standard that this court has put in place for dismissing any civil action at the outset of the case at the pleading stage. This case never got beyond the pleading stage.
How does this case differ procedurally from Valpreda?
I don't think it differs procedurally in any significant or material way from this case, Your Honor. Both cases involved a decision by a probate division judge. In fact, the same probate division judge involved in this case. And in both cases, the probate judge summarily dismissed a probate petition based on the judge's view that the probate division can exercise some type of gatekeeper role in deciding which cases get into probate court. And that is completely wrong according to Valpreda. The probate division does not serve as a gatekeeper. If a party invokes the jurisdiction of the probate division, the only way the probate division can dismiss at the pleading stage is to apply a Rule 12 judgment on the pleadings standard, where the petitioner or the plaintiff's factual allegations have to be deemed to be true. Any contrary allegations have to be deemed to be false. And the dismissal is only appropriate where the court can find that under the very liberal notice pleading standards in this state, a petition does not state any possibility of a claim for relief.
There is no Rule 12 in the probate rules. So what is the rule that applies? And I understand dismissal was talked about in Valpreda, but where is the authority in the rules themselves, the probate rules, to apply the standards under Civil Rule 12?
There is no authority for that in the rules, Your Honor, but Valpreda is the authority that we rely on. The decision in Valpreda says very clearly that the probate division does not have any authority to dismiss a probate trust petition. That was a trust case like this one. The probate division does not have the authority to dismiss outside the confines of the normal process for dismissal of a petition at the pleading stage of a case. That's our authority, Valpreda. And we think it's four square on point.
So, Attorney Bouffard, so from your perspective, the probate court's actions now leave the trustees unaccountable.
Yes,
Is that
Your Honor.
correct? And this is a court of equity, and it is to ensure accountability because it's in contravention, I think, of what, 14 VSA 205. And so this has essentially left your clients with absolutely no recourse, nothing to do if the entire trust is gone at the death of Ms. Milot. The fact that she's still alive does not make a difference.
In our view, Your Honor, the fact that she's still alive does not make a difference because she is unable to amend or revoke the trust. And that means she's unable to hold the trustees accountable herself because she lacks capacity to do anything about any wrongdoing by the trustees. Ordinarily, the settlor of a inter vivos trust, if the person has capacity, can protect herself by discharging a trustee who was not acting appropriately. But here she can't do that.
However, our Chief Justice, I think, just asked the question that there have been no findings as to her incapacity. Is that correct?
There have been no findings.
Do we need that?
We want the opportunity to show that she lacks testamentary capacity, Your Honor. That's what we alleged in the probate division. We asked the probate division for the opportunity to prove that she lacks testamentary capacity and for the opportunity to prove that there is no one else that holds power to revoke. We were denied that opportunity by the probate division because of its summary dismissal of the petition.
Well, let me ask the question, assuming the primary beneficiary is incapacitated and assuming there is no one holding a power that she's given them, who does get to hold the trustees accountable? If that's the case, is there anyone?
There's no one, Your Honor. That's the point. That you've hit the nail squarely on the head. There's no one. Now, my brother argues in his brief that, well, there's a possibility that a guardian might be appointed for Marsha Milot or that a conservator might be appointed for
Well,
Marsha
apparently, Ms. Milot signed a power of attorney to her daughter, right?
That's our allegation, Your Honor. Again, the trustees played a little hide and seek with us on that question because they never actually produced a copy of the power of attorney to us, despite our request. But our inference from their failure to produce the power of attorney is that it does not grant to Valerie Widerhorn, the agent, it does not grant to her the authority to do something like
Even if it's a durable power?
Your Honor, the Chief Justice, the power of attorney statute, I don't have the site at the top of my head, but it's in our brief. The power of attorney statute says that in order for an agent under a power of attorney to have authority to revoke a trust, the power of attorney has to specifically and expressly grant that authority.
In the document.
In the document. And we asked for the document here and the trustees did not provide it. We think we can prove that Ms. Widerhorn, as power of attorney, does not have the authority to revoke the trust. But we were denied the opportunity to discover that information and make the proof.
So, Mr. Bouvard, if the person who set up the trust becomes incapacitated, so then it goes from revocable to irrevocable, and there's new trustees, who do the trustees have a fiduciary duty to? To the trust and to what other individuals?
The fiduciary duty of the trustee is owed primarily to the settlor of the trust.
And any beneficiaries of the trust?
I would argue, Your Honor, that when you have the facts that we have in this case, the duty also extends to the remainder beneficiaries because the trust has become much closer to an irrevocable trust than a revocable trust. Under the circumstances of this case, under the facts of this case, the trust is revocable in theory only. In theory, Marsha Milot suffers from advanced dementia. And so, I suppose in theory, maybe she will recover. Medically, the chances of that, to my knowledge, are slim to none. But in theory, she might recover. If she recovered her testamentary capacity, then the duty would be owed solely to her.
How, I'm sorry.
Oh, go ahead, Chief.
Does that answer your question?
Well, no, I think you're ready to, just that it goes solely to her if she would if she were to regain her capacity,
Correct.
even for a short period of time, and she could revoke the trust. She doesn't regain her capacity, then who does the trustees have a fiduciary responsibility to?
They still owe her fiduciary duties because she's the settlor of the trust and she's the current income beneficiary. So the trustees owe primarily fiduciary duties to Marsha Milot, but she's not in a position to hold the trustees to those fiduciary duties. And our argument is that under these circumstances, the remainder beneficiaries need to be allowed to step up and really act in Marsha's stead to hold them accountable to the duties that they owe to Marsha while she's alive. That's our view of it.
Right, and the consequence of taking a different view is the trustees are untethered, unsupervised and untethered.
They're unsupervised. They could loot the trust completely, and no one could do anything about it until after Marsha Milot dies.
Before you run out of time, I want to ask you perspective on the Vermont comment to 603 under Title 14A and how that impacts the position you took a few minutes ago with respect to the power of attorney.
Thank you, Chief Justice. The Vermont comment is it's not binding in any way on this court. It's not binding authority. It's useful guidance, but it's not binding in any way. And if you read the Vermont comment carefully, it assumes that someone, namely, I think that the terminology used in the comment is that an agent can always act for the settlor of the trust.
Right, and it talks specifically about subsequent mental incapacity of the settlor.
That's right, it does.
Yeah.
What it doesn't deal with is the circumstances of this case. Because it doesn't deal with the circumstance where not only is there no agent under a power of attorney who can exercise the power to revoke, but there's no other party. There's no guardian, there's no conservator, there's no other agent that can possibly exercise the power to revoke. The way I would think about it, Your Honor, is that the court needs to read Section 603 and Section 205 together here. Section 205 is not in the Uniform Trust Code. Section 205 is unique to Vermont.
What does it say?
It says that the probate division can always exercise equitable jurisdiction in trust matters. The Uniform Trust Code on which the Vermont Trust Code is based is a uniform statute. The comments to the statute make it very clear that the intention of the drafters of the uniform statute was to codify what was readily subject to codification in the statute. They didn't attempt to codify the result of every single possible case imaginable that might arise under the trust code. Section 205 was included in the trust code to make sure that in cases that couldn't be anticipated by the drafters of the uniform statute, the court could exercise equitable jurisdiction to make sure that there was accountability of the trustees. Accountability of trustees has been fundamental to the equitable jurisdiction in this state since the 1800s. We cite Wade v. Pulsifer from 1881, making it very clear that it's at the core of an equity court's jurisdiction to make sure that trustees are held accountable, especially where there are allegations of self-dealing. That's this case.
If we remand, what relief was requested in the petition that remains to be granted?
We are seeking additional information from the trustees about their administration of the trust.
Is that requested in the petition?
It was not requested in the petition, but it was requested subsequent to the petition. The procedure, I'm sure the court can imagine, the probate division is a little looser than in ordinary civil litigation. There were multiple filings by the petitioner and the respondent in the probate division. I think they need to be all viewed as pleadings. I think the way to look at it is that there were amendments to the pleadings made as multiple filings were made.
There were letters. There were many letters.
Letters and briefs, Your Honor. But I think they need to be viewed as really pleadings in the probate division. And in those submissions, there were multiple requests for additional information from the trustees and an opportunity from the probate division, seeking an opportunity from the probate division to get more information. Thank you, Your Honor.
Thank you very much. We'll hear from counsel for the appellee. Please come on up. And for the record, please introduce yourself and your client.
Morning, my name is Matthew Zadowski. I represent the appellees and co-trustees Valerie Wiederhorn and Curtis Henniger.
Thank you.
May it please the court. I've given significant thought about how to present this case to the court as appellee, and I understand that the court's familiar with the briefing and the record. I want to address some of the points raised by opposing counsel, but I want to make sure that the court understands some of the background. And I think that the appellant has attempted to portray this as a complex case, and it's not a complex case. This is an intra-family dispute about money. And to properly decide it, we need to understand the posture of the case. And many of you have touched on the posture of the case in your previous question.
This isn't the case about accountability, about how you can account for interest to a person maybe who has a disability or cognitive impairment to beneficiaries who may inherit some money once the trust is extinguished.
Your Honor, this is a case about a request for a trust petition and subsequent follow-up requests for information to flesh out facts and to determine whether the facts are as petitioner believed them to be. And there was the relief that was requested in the petition has been granted. The probate court then.
That's a copy of the trust document and the trust report, so-called, under the statute.
Yes, Your Honor.
Yeah, but now he says there's the concern about self-dealing. Why not let them look at the materials? What is the harm in letting them, especially in light of the fact that they're residual beneficiaries? Why not just let them see what's there? What are the trustees doing?
Well, I'm not sure that there's any harm per se, but the Vermont law is clear that the duty is owed to the settler.
And if the settler's incapacitated or unable to act?
Well, this is the part of the problem, Your Honor, with being here today, is that there's no factual finding that the settler is incapacitated.
Well, isn't that why we should send it back?
Well, or affirm. I mean, the petitioner had an opportunity under Vermont law to appeal this for a de novo trial at the Superior Court. And if the petitioner wanted to get a factual record developed as to incapacity or other issues, there was an opportunity to do that. Instead, the petitioner has come here under a separate statute, 12-2551, which very clearly provides, and this court has held, does not permit this court to sift and weigh and make factual findings in the first instance. And so everything that was presented to you in the last 15 minutes by petitioner is based on supposition. And they're asking this court to enter into a sort of policymaking. What are remainder beneficiaries entitled to under fact pattern X or fact pattern Y?
Are you saying that the failure to appeal to the Superior Court for a de novo trial effectuates a waiver of, or somehow creates a bar to us remanding back to the probate court for findings of fact?
Well, I think that the court has great latitude in how it conducts its affairs.
Yeah, but there's no law that says that, right? Is there?
I know,
No.
these are questions of first impression,
Yeah.
but generally speaking, when this court answers questions of first impression, it does so with a factual record
Yeah.
developed. And if the court wanted to say, Marsha Milot is incapacitated, and therefore the trustees are not answerable to anyone, if there were a record, the court could do that.
And maybe I read this wrong, but I didn't realize it's even a disputed fact that she had some level of cognitive impairment.
There's no dispute that she has dementia, but there's a difference between being incapacitated such that she stepped down as trustee of this complex trust versus being legally incapacitated as a matter of
You're
Vermont
saying the
law.
person with dementia would in some ways have legal capacity?
I think that lawyers frequently put their own spin on what dementia is. And I think dementia is different for every person who has it. It certainly is gradually increasing. It certainly may affect one person differently than another. I think that the broader point is that there's been no legal determination by a judicial body that Marsha Milot lacks legal capacity under Section 601 to revoke this code. There's been no finding that she couldn't have someone appointed or a power of attorney to revoke the trust.
And your position is that this record cannot be developed in the probate court now because that opportunity has passed by and the remedy was to accept what the probate judge said and then take an appeal to the Superior Court for de novo purposes. Is that?
I believe that that's a very valid argument. I believe that what the probate court did is it granted the relief that was requested in this petition. And then applying Section 205, it evaluated petitioner's allegations and evaluated the trustee's response. And the court just mentioned the kind of letter writing campaign. There was a letter writing campaign. There was a series of briefing on mootness. The probate court looked at the tale that was being told by both sides. And the court ultimately then read the trust. And what the trust says is the trustees have discretion to distribute all of the net income and as much of the principal of this trust as they see fit to provide for Marsha in their discretion. And so when we talk about should a remainder beneficiary under the facts of this case or generally have some sort of oversight capacity, in this case, there is no vested interest and there is no guarantee that the petitioners have anything coming to them from this trust. Now, if the trust was structured differently, if there were guardrails in place that said you can only spend so much of the principal, you can only, take net income and spend the principal in this way, that might be a different question because then petitioner would have a valid interest, not a vested interest, but at least a valid interest in maintaining, maintaining the trust assets. In this case, the trust is completely free of guardrails. There's nothing that would stop Marsha Milot from requesting distribution of funds to fund her lifestyle. And this issue is extensively briefed. This is an extremely privileged family and woman. She spends a lot of money. They travel, they give generous gifts, they have expensive real estate holdings, that they have high taxes. And as Marsha's income has gone down in other areas of her life, spending it from the trust necessarily went up. It's not a nefarious plot that requires extensive discovery.
But it could be. I mean, if the trustees were paying themselves an extraordinary amount of money out of the trust, giving themselves a fee, or if they were investing in high-flying, high-risk investments with trust money, That, would the beneficiaries have a right to know that so that they could police it?
Well, with respect to compensation, certainly, but they've received an 813C report, and there is no compensation. Investment in high-flying investments, there's broad discretion. And in fact, under Section 813 and under even a qualified beneficiary, even a person who's entitled to an increased level of information isn't entitled to granular detail level information about trust administration. That they're not allowed to dig around in the books, even at the highest level. Now, with respect to a fiduciary, there's a statute. If a remainder beneficiary thinks that a trustee is self-dealing, there's Section 706. You know, they can file an action and say, I want this person removed. I'm alleging self-dealing. I'm alleging fraud, but then they have to do it with specificity, and a different standard exists. This is just a, this is just a broad fishing expedition.
Except you've got the judge's comment about the tension he notes and has had a concern about apparently for some time with respect to the Vermont comment, so-called under 14A 603, and the ability, the provisions under Section 813 that you were just alluding to. What do you say about the Vermont comment?
I think that the Vermont comment makes clear that to the extent that some states have said that settler incapacity is a valid consideration with respect to whom the duties are owed, Vermont, the legislature elected not to adopt that language and has left, perhaps has left open the question, but at least in passing the law has said that a settler can become incapacitated and the duties are still owed to him or her. And that is what is happening here. The trustees in this case are settler's daughter and settler's husband. Settler's daughter was installed as a co-trustee in 2018, far before there were any allegations or assertions of the beginning of dementia. Nobody has argued that Marsha Milot lacked capacity to make this trust. Nobody has argued
2018 trust.
the 2018 trust. Nobody has argued that Marsha Milot lacked capacity to determine how the income in principle would be used during her lifetime. And I know this is obvious, but this is a living trust. Marsha Milot is a living person. And the idea that a remainder beneficiary with no vested interest in a single dollar of the trust assets is coming in and demanding oversight at a granular level. I mean, I clerked for an appellate court, and I remember sitting with the judges and laughing when one of the parties did the parade of horribles, right? But there is an idea that they are asking for medical information about Marsha. They are asking for a determination.
But there is at some level the potential for a revocable trust to become irrevocable by virtue of the incapacity of the settlor, isn't there?
That is there is case law in other states holding to that effect. I have not read a Vermont case that sets that.
Well, I don't think we've seen it before.
Do you quarrel with that outcome?
I think from a public policy perspective, it's an interesting conversation to have. But I don't think that this court under 122551, which is what we're here under today, under the court's normal practices, would generally make new law on this topic without a factual record. I don't.
But wouldn't that require a remand to get a factual record?
But a remand, Your Honor, respectfully, a remand on what cause of action? I guess that is the question. There was a petition, it asked for a trust, and then a letter writing campaign began. And the co-trustee's position uniformly has been, the petition is moot. You have the requested relief. If they wanted to bring another or a different cause of action, that is a separate question, but that is not the question before the court. The issue, I suppose if there were a remand to the probate court, the question in the first instance to the probate court would be, what information are you entitled to? And under what authority are you seeking it? You know, are you saying that this trust has become irrevocable? And if so, is there an avenue to prove that fact? Are you saying that you are a qualified beneficiary and therefore entitled to a different set of information under 813A as opposed to 813C? There are so many unanswered questions. And I think that the reason that the probate court, my understanding of why the probate court acted the way that it did in making this ruling is the court was being asked to sit in equity. We have a statute, we have 603. It's very clear. And the court said, well, I'm looking at 603 and I'm also looking at 205. And I'm thinking about whether to use my discretion to apply my chancery powers to
Right.
essentially
That's what he said.
to
what he
overrule. I'm going to overrule 603. And because I'm going to do that, I want to talk a little bit about the facts. And so the parties exchanged all sorts of dialogue about the facts. Co-trustees filed, I believe, 3 verified pleadings. You know, the judge looked at the facts and the judge said, is this person, petitioner, owed any duties by these trustees given the specific trust language and under Vermont law? And the
Was there
judge,
ever a request for any power of attorney?
I'm sorry.
Was there ever a request for any power of attorney?
Well, the court, we never did formal discovery requests. What is in the record are these campaigns, or I'm sorry, that's a misspeak. There are letters that say, we want information about Marsha's health. We want information about Curtis Henniger's acceptance of his authority to act as trustee. We want information about spending, about trust, you know, so there were these broad categories of information and they were answered to the extent that we could. And the court had 3 interim orders, I think. And the second interim order said, I'm weighing, you know, the 2 of your positions. And the only concern I have left is I want to understand if the increased trust spending is going to Marsha's benefit. So there was this, and it all got briefed again, Your Honor. There was a whole nother round of briefing in which, you know, it was laid out, you know, Marsha has these health concerns. Her healthcare expenses have gone from X to Y over the course of 3 years. The probate court does not see any reason to understand that trust assets are not being used in Marsha's best interest. And therefore, when you're being asked to sit in equity, I mean, the court didn't have to apply some sort of Rule 12 standard that doesn't exist at probate law. The court looked at it and said, I decline to use my equitable powers to answer these questions. I believe that the trustees have demonstrated that they are acting in Marsha's best interest, and that is who their duty is to, as a matter of Vermont law. Thank you.
Thank you very much. Do you appellant have any time left?
Appellant has no time remaining.
Okay, please call it conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.
Thank you both.